The next speaker is Professor Ral. You have the floor.
Thank you very much. And I have to thank Professor Rothwell for an excellent first lecture on a topic of great importance and interest. It is indeed a great honor for me to speak at this very prestigious conference on the law of the sea, generously hosted by the Korean Foreign Ministry, also the Tribunal, and of course the Korean International Law Society. And today, this year, we are celebrating the 40th anniversary of what I really do believe to be one of the greatest achievements for international law. And I say that coming from a non-state party country, but the Law of the Sea Convention truly is an important feat, and I'm not sure we would have it today, really. So I'm very pleased to be speaking today. Yes, I will be speaking and examining in some detail what is also known as case number 21, the request for an advisory opinion submitted by the Sub-Regional Fisheries Commission. And in starting this, I would like to first begin with a statement made by the ICJ, the International Court of Justice, on advisory opinions. And this is actually on this website, quote, "Despite having no binding force, the court's advisory opinions nevertheless carry great legal weight and moral authority. They are often an instrument of preventive diplomacy and help to keep the peace. In their own way, advisory opinions also contribute to the clarification and development of international law and thereby to the strengthening of peaceful relations between states. This certainly would equally apply to the Law of the Sea Convention and to the role of ICLOS." Now, as already outlined by Professor Rothwell, unlike the ICJ, which does have express jurisdiction under the Charter, or the Seabed Disputes Chamber, which has express mandate under Part 11 of the Law of the Sea Convention, ICLOS does not have express advisory competence under the Convention itself. Rather, the jurisdictional competence derives from the language of Article 21 of the statute, referring to jurisdiction over all disputes and all applications submitted to it, and Article 138 of the Rules of the Tribunal. There are essentially three conditions required for an advisory opinion from ICLOS. Number one, that there be an international agreement that is related to the purposes of the convention. Two, the agreement provides the tribunal with advisory jurisdiction. And third, it presents a legal question. The first such request for an advisory opinion under Article 138 of the rules was submitted in 2013 by the Sub-Regional Fisheries Commission, in short, the SRFC. It is a regional fisheries body comprised of 7 West African states. Now, in 2012, the Commission had amended its existing convention, which had been adopted in 1993, and it's a long name. I'll just say it's the Conditions of Access Convention, to update it to reflect developments in international law, and particularly concerning illegal, unreported, and unregulated fisheries. The amended convention also authorized the permanent secretary to request advisory opinions from the tribunal. And on 27 March 2013, the SRFC presented what was the first advisory opinion request to the tribunal. And now there are 4 questions. Oops. I actually don't have a detailed PowerPoint presentation, but I thought the nature of the questions being so, it would be helpful for you to see them on the screen. So essentially, in brief, the first one concerned the obligations of the flag state for IUU fishing in the exclusive economic zones of third-party states, the question of the extent to which the flag state would be liable for IUU fishing activities by vessels sailing under its flag, The third had to do with the liability of international agency that had licensed fishing and had flags flying under its, ships flying under its flag. And also the third had to do more with the coastal states' rights and obligations concerning the sustainable management of shared stocks and stocks of common interest. Now, in total, if I counted right, some 21 state parties, including the U.S. as a party to the UN Fish Stocks Agreement, submitted written statements, and many also participated in the oral arguments. In addition, international and regional organizations also submitted written statements and appeared for oral arguments. And there was one amicus curiae written statement from an NGO, the World Wildlife Federation. A number of states either expressly challenged the advisory jurisdiction of the tribunal or expressed some doubt and called on the tribunal to act with caution. However, it is also notable that others did not challenge its jurisdiction, and in reality, a majority of the states were silent. So how we read that is another matter, and I really don't want to dwell too much on the jurisdictional issue, because I think there's been too much focus on that, and what I would rather do is to focus on the substantive questions and how this advisory opinion actually has advanced the Law of the Sea Convention into the future generation. So the tribunal decided unanimously that it had jurisdiction to provide an advisory opinion. Now, before I do go into detail, I think it's important also to understand the importance of the issue itself, IUU fishing. It is a concept that is not in the convention. It is a concept that emerged subsequently to the adoption of the convention in 1982. Indeed, the first use of the term illegal, unreported, and unregulated fishing was made by the Commission for the Conservation of Antarctic Marine Living Resources in a 1997 report. It was later further developed by the Food and Agriculture Organization, FAO, which developed and adopted a number of instruments, notably, first, the International Plan of Action to Prevent, Deter, and Eliminate Illegal, Unreported, and Unregulated Fishing in 2001. This is a soft law instrument. Moreover, one needs to underline the importance, the seriousness of the problem of IUU fishing. It is a global problem, but in particular, West Africa is one of the regions most affected by it. Indeed, studies show that for 7 states, their annual loss is estimated at some nearly $2.5 billion annually, a significant sum for developing countries in particular. Indeed, the second written statement of the Sub-Regional Fisheries Commission provides detailed cases of IUU fishing in their respective EEZs, noting how the problem had grown exponentially during the past 20 years, and also outlining in detail the gaps in the existing international legal framework that had prompted their requests and these questions. So now I will delve into the substantive questions. But I should add also that there were criticisms by states that the questions were either too vague, too general, some even challenging admissibility on this. So the tribunal responded by reformulating these questions and limiting the scope of their application to the geographic area of the MCA convention itself and not to IUU fishing in general. Nonetheless, in practical terms, the tribunal's findings, of course, have relevance beyond the maritime zones of the SRFC member states. So, in regard to question 1, the first challenge for the tribunal was to incorporate the concept of IUU fishing into the convention itself, the Law of the Sea Convention, which does not include any express reference to the term or implicitly as well. The tribunal started first with the definition provided by the revised Minimum Conditions of Access Convention of the Regional Fisheries Commission, which was based on that of the FAO instrument. These are long, I'll just say it in short, the IPOA-IUU definition, which, as I mentioned earlier, is a soft law instrument. However, the tribunal took notice that this definition was taken from a voluntary instrument, but also observed or noted that the definition of IUU fishing had subsequently been incorporated and reaffirmed in the Port State Measures Agreement, which is a binding agreement adopted under FAO, and today I looked, it has some 100 state parties. And it had also been adopted in decisions of regional fishery management organizations, the national legislation of a number of states, and of course the law of the European Union. Now, admittedly, there was some expectation in some circles that the tribunal would go further and possibly examine whether this definition was now part of the corpus of customary international law. However, the tribunal was cautious, although it does appear to have opened the door. Indeed, Judge Paik is here. In his separate opinion, he did write that the tribunal should have addressed in more detail the important developments on IUU fishing instruments in the post-UNCLOS era. He expressed his view that there was a compelling reason for the tribunal to examine whether and to what extent these developments should be considered in addressing question 1. And I agree with Judge Paik. The tribunal could have gone beyond noting and perhaps engaged in a deeper analysis of whether the definition of IUU fishing, the developments that had taken place since, and the status under international law. Nonetheless, the opinion has contributed to important ways to placing IUU fishing within the context of the convention. First, in relation to the part of IUU fishing being unregulated, the tribunal stated that, quote, the adoption by the coastal state of the conservation and management measures for all living resources within its exclusive economic zone is mandatory, according to Article 61, paragraph 2 of the Convention. The tribunal further made clear that the coastal state has the primary responsibility to take the necessary measures to prevent, deter, and eliminate IUU fishing within its exclusive economic zone. However, the tribunal also emphasized that this did not release other states from their obligations. So I will start with their obligations. Just see. Oops. Now, on the flag state obligations, the tribunal observed that the issue of flag state responsibility for IUU fishing is not directly addressed in the convention, and so proceeded to examine this issue, quote, in light of general and specific obligations of flag states under the convention for the conservation and management of marine living resources, end quote. And in relation to the general obligations, is that it? Yes. The tribunal listed Articles 91. I have them listed here, so in the interest of time, I won't read through what they stand for each. Articles 92, 94, 192, and 193. For the specific obligations, the tribunal pointed in turn to Article 58, paragraph 3, and Article 62, 4. So I want to start with Article 94.1 on flag state obligations. And here what's key, and I have the, I think I have it, let me see. I have to put my glasses on if I have the right slide up. Nope, I don't, sorry, there we go. Article 94.1 outlines the flag state obligations. And here, when we look at paragraph 1, and this is the key, the obligation of the flag state is to effectively exercise its jurisdiction and control over ships flying its flag in administrative, technical, and social matters. Now, this trio of administrative, technical, and social matters could have been interpreted in a stricto sensu manner by the tribunal so as not to encompass specific activities such as fishing. But the tribunal instead interpreted Article 94 as applying to fishing vessels based on the opening qualifying language of paragraph 2 of, quote, in particular. The tribunal interpreted this qualification preceding the list of measures as being one only being indicative and not exhaustive. So in interpreting Article 94, and I will quote, the tribunal said, the flag state, in fulfillment of its responsibility to exercise effective jurisdiction and control in administrative matters, must adopt the necessary administrative measures to ensure that fishing vessels flying its flag are not involved in activities which will undermine the flag state's responsibilities under the Convention in respect of the conservation and management of marine living resources. Secondly, the tribunal linked flag state obligations for fishing activities with conservation and management of marine living resources and the protection of the marine environment. Specifically, the tribunal cited its previous preliminary measures decision in the southern bluefin tuna case that, quote, the conservation of the living resources of the sea is an element in the protection and preservation of the marine environment in Article 192 of the Convention, and imposes on all state parties an obligation to protect and preserve the marine environment, such obligation applying in all maritime zones. Accordingly, the tribunal said, and I'm quoting because I think it's important, these quotes, quote, means that the flag state is under an obligation to ensure compliance by vessels flying its flag with the relevant conservation measures concerning living resources enacted by the coastal state for its exclusive economic zone because they constitute an integral element in the protection and preservation of the marine environment. In relation to the specific obligations of the flag state, the tribunal went on to interpret Articles 58(3) and Article 62, paragraph 4, together with Article 192, to create an obligation for the flag state to take the necessary measures to ensure that their nationals and vessels flying their flag are not engaged in IUU fishing. So here, it is the obligation of the flag state to take the necessary measures. Next, the tribunal interpreted Article 58, paragraph 3, that as nationals of other states fishing in the EEZ under Article 62(4), establishing a due diligence obligation of flag state to ensure that its nationals comply with the conservation measures of the coastal state. And in referring to the due diligence obligation, it was then referring to its Seabed Disputes Chamber advisory opinion from 2011. The tribunal also referred to the ICJ Pulp Mills case concerning, that had elaborated on the meaning of due diligence as one that entails, and we're familiar with this, not only the adoption of appropriate rules and measures, but also a certain level of vigilance in their enforcement and the exercise of administrative control applicable to public and private operators. All right, so then in question 2, well, there's no mention of liability in the Law of the Sea Convention or even in the MCA Convention itself for flag state liability for IUU fishing. So the tribunal relied on Article 293 of UNCLOS, which refers to the application of other relevant rules of international law. And in this case, it was, of course, the ILC Articles on State Responsibility. Importantly, the tribunal clarified that the question of liability was not the result because the vessel flying its flag had violated the coastal state's laws, but rather it was the failure of the flag state to comply with its own due diligence obligations concerning IUU fishing activities conducted by vessels flying its flag in the exclusive economic zones of the SRFC member states. Also, I should add, the tribunal clarified that frequency was not relevant, that one single incident itself would suffice to establish a breach of a flag state due diligence obligation. Now, in question 3, and then I'll just very briefly mention this, basically, again, in reformulating the question somewhat, the tribunal interpreted international agency to mean an international organization, and basically clarified that it considered the question to apply only to international organizations referred in Article 305, paragraph 1F, and 306 of the Convention, as well as Annex 9. Essentially, situations where member states had transferred competence to the organization over matters which the only one, of course, right now we have would be the European Union, European Community, which has competence, exclusive competence over fisheries in the European Union. Importantly, the tribunal found that in this case it would be the EU, could be held liable for the failure to exercise due diligence over fishing vessels under its flag engaged in IUU fishing in the exclusive economic zone of the SRFC member states. And last but not least is question 4. The tribunal clarified the obligations of the SRFC member states to cooperate with competent international organizations in order to agree on the necessary measures and to coordinate and ensure the conservation and development of shared stocks in general, tuna stocks in particular, and that these should be designed in accordance with the best scientific evidence available. All right, well, so now some reflections. And it's been some 7 years since the advisory opinion. Time flies. And again, I just want to say, most of the attention when you look at the literature, it has to do with whether the tribunal had competence or not, jurisdiction or not. And rather, I think there should be more attention on how this opinion has contributed to the interpretation, clarification, providing guidance, for example, to the SRFC member states on a matter of great importance, IUU fishing. And overall, I think the larger question we're looking at is the capacity of the Law of the Sea Convention to address contemporary issues and future ones. Indeed, to enhance the effectiveness of the Law of the Sea Convention. Now, if we acknowledge that IUU fishing is a post-Law of the Sea Convention concept and development, and given the broad ocean scope of the convention, then what methods are available to assess how and whether IUU fishing activities come under the convention? Well, one option is to amend the convention, but that is not a practical or realistic option. Another is to develop a new implementing agreement specifically addressing IUU fishing, such as the case with the UN agreement for straddling and highly migratory fish stocks. But as we know, this is very time-consuming. Indeed, we have the current example of the BB&J. Further, I would add that already the FAO has been very actively developing these instruments. They exist. A third option would have been for the SRFC to have brought a contentious case under Part 15. And the fourth is, of course, going the advisory opinion route. The last option is the less adversarial approach, which is an advisory opinion, with the objective of clarifying international law norms and not taking an accusatory approach. It is the process of providing guidance and interpretation, and I would add along the lines of what the ICJ has stated. Indeed, this is a point that former Judge Rudiger Wolfer made in his chapter on advisory opinions, are they a suitable alternative for the settlement of international disputes, where he quotes Judge Bergenthal concerning the Inter-American Court of Human Rights, where he stated that the use of advisory opinions, quote, does not stigmatize a government as a violator of human rights in that in that case. However, it makes the abstract legal issue perfectly clear for the government, for any government wishing to avoid being held in violation of international legal obligations. And I think we can see the same in this particular case concerning IUU fishing. A fifth possible option could be using the meeting of the state parties to the convention, SPLOS, but as it is currently constructed, this is really not a viable option, although it could have provided possibilities for application of, for example, the use of subsequent agreement and practice under the Vienna Convention of the Law of Treaties, I was going to say treaties, the Law of Treaties under Article 31. But as we see in the current advisory opinion, despite some of the criticisms, the tribunal was very successful in bringing IUU fishing within the scope of a convention that had predated the notion of IUU fishing. And as far as my humble view, the outcome was far from being a controversial outcome. Indeed, it should be very welcome by states to have clarity on one of the major international problems. However, if I were to be critical, the tribunal could have developed in more detail its methodology and reasoning for what really was, in my opinion, an evolutive interpretation of the convention. Now, my last reflection is the role for evolutive or dynamic interpretation of the Law of the Sea Convention. And as comprehensive as it is still not able, it could not have, and it will not have, be able to predict and address new and emerging issues. And there may be different opinions on the role of evolutive interpretation or the temporal aspects of treaty interpretation, but in the case of the Law of the Sea Convention, it is natural. Indeed, the very opening of its preamble sets out the broad objective, prompted by the desire to settle in a spirit of mutual understanding and cooperation all issues relating to the law of the sea, and aware of the historic significance of this convention as an important contribution to the maintenance of peace, justice, and progress for all peoples of the world. Certainly an advisory opinion would serve that function. Indeed, one can discern the intent of the negotiators to have a convention which is described by, of course, we know very well, President Tommy Coe as a constitution for the ocean, that can have a meaning and relevance for all issues past, present, and future. And we need to use different tools, a dynamic system of interpretation that will allow the provision of the convention to be applied to new situations as they emerge. And we have a very obvious one that's emerging, and that is climate change. And already Professor Rothwell has listed some others. I just don't want to spend too much time because I want to leave time for discussion. But climate change is another issue that postdates the Law of the Sea Convention, and it is posing many legal questions, including, for example, questions related to protection and preservation of the marine environment. And I know at the opening of this conference, we had many statements on that. For example, can greenhouse gases, in particular excess carbon dioxide, be considered pollution under the convention? Do the obligations under Article 194 for states to take all measures consistent with this convention that are necessary to prevent, reduce, and control pollution of the marine environment from any source apply to climate change? Do states have due diligence obligations? What are these obligations? Well, so if we need to answer these questions, does a state need to bring a contentious case? And may I say something, and this will be, I think, the last point I will make. Contentious cases are binding upon the parties only to the case. And only those parties in general can participate. And yet we know that even though contentious cases are binding only on the parties, they do have precedential value. They will influence international law. On the other hand, advisory opinions are inclusive. And we know in all the advisory opinions, including Case 21, many states participated. And indeed, this has been listed as one of the advantages, of course, of advisory opinions. So I think the question about whether it overrides the consent of states, this is one of the questions raised. On the other hand, it is a process by which all state parties can participate and provide a view concerning the interpretation and how a specific situation, legal question, will apply under the convention. So, in conclusion to this, I would like to say that in examining the effectiveness of the law of the sea for future generations, Judge Paik in his keynote speech stated that advisory opinions will be material in enhancing the effectiveness of the convention for the future as new issues emerge concerning the law of the sea, and I could not agree more. So in conclusion, I thank the Korean Ministry of Foreign Affairs, the International Tribunal for the Law of the Sea, and the Korean International Law Society. Thank you very much.
Thank you, Professor Oral, for your statement and for the analysis you have done, and pointing out that the literature mostly points out procedural matters rather than the substance of this SRFC advisory opinion.